Honorable Carlos Zarate be recognized for his interpellation.
Likewise, the Honorable Carlos Zarate is recognized. Sir, you may have the floor.
Thank you, Mr. Speaker. Colleagues, good afternoon. Will the good sponsor of RBH2 yield to some questions in the interpellation?
Willingly, Mr. Speaker.
Thank you, Mr. Sponsor. Mr. Speaker. To the recollection of the good sponsor, is this the first time that a proposed amendment to our Constitution is deliberated or debated in this floor?
This is the third time. During the time of the late Prospero Noglares, the late Speaker Nograles, the proposal to amend the Constitution reached as far as the sponsorship speech, and the time of Speaker Belmonte, the RBH1, it reached as far as adoption on second reading.
Thank you, good sponsor, Mr. Speaker. So, and in fact, in these three occasions, the same proposals were made. Generally, amendments to the economic provisions of the 1987 Constitution.
That's correct.
My recollection
The
correct, Mr.
proposals
Sponsor?
were confined only to the restrictive economic provisions of the Constitution.
By the way, Mr. Sponsor, Mr. Speaker, just for the record and to put into context the current proposal to amend our Constitution, will the good sponsor, Mr. Speaker, recall to us what is the mode, what are the modes to amend our Constitution as laid down in the 1987 Constitution? Mr. Sponsor, Mr. Speaker.
Well, under Article 17, Section 1 of the 1987 Constitution, there are three modes of proposing amendments to the Constitution. One is by Congress, 3/4 of all its members. The other one is call for a constitutional convention, and the third one is people's initiative.
So generally, there are three modes in proposing or in amending or revising our Constitution. Congress was the first. Second is the Constitutional Convention. And third, by a people's initiative. Is that correct, Mr. Sponsor?
That's correct.
Now, will the good sponsor state for the record what is the mode of amendment that we are following now, Mr. Sponsor, Mr. Speaker?
The one that we're taking now, and pursuant to Article 17, Section 1 of the 1987 Constitution, and consistent with the power granted to Congress to determine the rules of its own proceeding, where we adopted the rules in acting upon all proposals for amendment to the Constitution. So under the House rules, the proposals for amendment to the Constitution shall undergo the procedure for the enactment of bills.
Enactment of bills, no? So you are saying, Mr. Sponsor, Mr. Speaker, that the mode we are following now is an amendment akin to legislation. Is that correct appreciation, Mr. Sponsor,
Well,
Mr. Speaker?
That is true because Congress is being empowered by the Constitution to determine the rules of its own proceeding, including the rules in determining how we propose amendment to the Constitution. In fact, under Section 15, Paragraph 2 of the Internal Rules and Procedure adopted by the Committee on Constitutional Amendments, as authorized by Section 34 of the House Rules, provides the procedure in proposing amendments or revisions, which I read, by Congress exercising its constituent power in separate session, a resolution of both houses which contains the proposed amendment or revision shall be filed. The adoption of the resolution under this mode shall follow the procedure for the enactment of a bill, but without the need of presidential approval. The required 3/4 votes shall be required during the third reading, both of the resolution in the plenary in both houses. So therefore, the House of Representatives when it referred the resolution proposing amendment to the Constitution to the Committee on Constitutional Amendments, has commenced its exercise of its constituent power. The committee, as an organ of the Congress acting as constituent assembly, is doing its role in the amendatory process when it heard and deliberated the RBH2.
Thank you, Mr. Sponsor, Mr. Speaker. So, is the good sponsor saying that the mode we are following now, and in fact, if the good sponsor can recall during one of the committee hearings, you mentioned that this is now the start of the Constituent Assembly. Did the good sponsor recall that statement, that that committee hearing is actually the beginning of a Constituent Assembly, Mr. Sponsor, Mr. Speaker?
Well, that's true. The plenary is now exercising its constituent power when proposing amendments to the Constitution.
And that is in line with the good sponsor's statement at the committee hearing, that in fact that committee hearing is also part of the Constituent Assembly.
Well, that's true, because the committee, as an organ of Congress, acting as an organ of Congress, is acting as a constituent assembly, exercising its constituent power. It is doing its role in the amendatory process when it heard and deliberated on RBH2.
Thank you, good sponsor, Mr. Speaker. On this proposed resolution about Houses number 2, it was stated that the voting of the Senate and the House of Representatives shall be separately, to be done separately. May we know, a good sponsor, Mr. Speaker, what is the wisdom behind the interpretation of voting separately instead of voting jointly, when in fact Article 17, Section 1 did not mention at all that the voting should be separate or jointly. No? It only mentioned that the proposed amendment or revision of the Constitution may be made or may be proposed by Congress upon a vote of 3/4 of all its members. Mr. Sponsor, Mr. Speaker.
Well, the Constitution, where Congress is empowered to propose amendment to the Constitution, only speaks of the number one mode: Congress, by a vote of 3/4 of all its members, may propose amendments or revision to the Constitution. Meaning, when you speak of Congress, it is the Senate and the House of Representatives. So the voting would be separately. Now, as to whether we have to conduct a joint session, the Constitution does not provide. There's a general rule that if the Constitution does not expressly or impliedly prohibit, then Congress can do so according to the rules of its own procedure. And therefore, there's no need for a prior act of convening Congress into a joint or a constituent assembly, as we call it, as Congress is already a constituent assembly as defined under Article 17, Section 1 of the 1987 Constitution. It does not transform itself into a different animal in order to be able to propose amendment, because the Constitution is simply or has simply given to Congress a constituent function. No preparatory joint session is needed before Congress can propose amendment, as it is a bicameral body.
Thank you, good sponsor, Mr. Speaker. May I inquire, Mr. Sponsor, Mr. Speaker, why is it that the power or the grant to amend or propose amendments to our Constitution, that particular provision, was not included in the article or powers specifically granted by the Constitution to Congress? Why is it not in the article supposedly enumerating the powers of Congress.
Well, the power to amend the Constitution is not included in the general legislative power granted to us by the Constitution under Article 6 of the 1987 Constitution. When we propose amendment to the Constitution, it is in the form of our constituent power, meaning it's the Constitution that says Congress may propose amendment, provided we need to muster the three-fourths vote of all its members.
Yes, thank you, good sponsor, Mr. Speaker. It is not included in the article defining the powers of Congress, Senate, and the House, because actually proposing an amendment or a revision of our Constitution is such a special power, and it is not actually part of the general legislative powers of Congress. Is that correct, Mr. Sponsor, Mr. Speaker?
That is correct, Mr. Speaker.
Yes. And in fact, because it is such a special grant of the Constitution, in Article 17, the voting requirement is different from the other voting requirement as laid down in our Constitution. No? When Congress if there's a need for Congress to vote. Is that correct, Mr. Sponsor, Mr. Speaker?
That is correct, Mr. Speaker.
Thank you. Now, so considering that it is not part of the ordinary or general legislative powers of the Constitution, the good sponsor earlier mentioned that what is in fact being done now, or the process we are doing now, is the constituent power. No? You mentioned a constituent assembly power, no, of Congress in proposing amendments to the Constitution. So that is why I inquired on the wisdom of that proviso in this joint resolution number 2, requiring a separate voting rather than a joint voting by both houses of Congress, no? When Article 17 is so silent about such a requirement. Will also do so. Is that what is the good sponsor is saying now, Mr. Sponsor, Mr. Speaker?
As long as it comes within the terms of Article 17 of the Constitution, then it is a sufficient mode of proposing amendments or revision to the Constitution. In amending or revising the Constitution, Article 17 of the Constitution does not require Congress to sit jointly or in a joint assembly, but only requires that it does so upon a vote of 3/4 of all its members. So, for as long as the 3/4 voting requirement is carry out the procedure which the House intends to undertake, and for RBH2 can be legally and constitutionally justified. And this is the position of the Chair.
Thank you, Mr. Sponsor, Mr. Speaker. Incidentally, Mr. Sponsor, Mr. Speaker, will the good sponsor update us? What is now the parliamentary status of this RBH2? Are we now debating here as part of the Constituent Assembly, or are we here debating as Congress, as legislative branch of the government, now trying to pass a resolution? Mr. Sponsor, Mr. Speaker.
We are now exercising our constituent power, specifically proposing amendments to economic provisions of the Constitution.
And by performing our as you mentioned, no, powers, constituent powers to amend and propose amendments to the Constitution, the good sponsor is saying that there is no need for this House, for this body, to declare itself as such. that the procedure is just a continuation. No? Just like earlier, there is a resumption of session. There is a earlier we debated on a particular bill, and then this particular resolution of both houses is subjected to a debate. No? So this is just a part of the regular legislative activities, no, that we are doing here. No? So you are saying that there's actually no distinction, Mr. Sponsor, Mr. Speaker.
Mr. Speaker, the House rules expressly states that the proposal for amending the Constitution, such as RBH2, shall undergo the procedure for the enactment of the bill. And the resolution itself specifically calls for a separate voting of each house. When you speak of distinction between legislation and proposing amendment to the Constitution, it has a distinction because when we legislate, we derive our power under Article 6 of the 1987 Constitution. That's where we are made as a legislative body. But when we exercise our power to propose amendment to the Constitution, we derive our constituent power under Article 17, Section 1 of the 1987 Constitution. So that lies the distinction.
Well, thank you, Mr. Sponsor, Mr. Speaker. But with the kind indulgence and due respect to the good sponsor, I don't see the distinction. No? Because as I've mentioned, we just continued with our proceedings this afternoon from reading additional reference of business, from taking on second reading the warehouse receipts law. Then we proceeded immediately in considering RBH number 2. So I cannot now make the distinction of our legislative power, legislative duties, as well as our duties as part of a constituent assembly, no, with we agreed earlier on that this is a special power, no, laid down in Article 17, and you cannot just say that this can just be a part of the ordinary legislative power. No? It's very clear that, at least to this representation, good sponsor, that lawmaking is very distinct function from amending or revising our Constitution. No? So, gaya ng nabanggit ko, as I've said, no? What we are doing now, I don't see that we, as a body, made that particular distinction, no? That we are now doing this as part of our constituent power, Mr. Sponsor, Mr. Speaker.
Well, the distinction also lies that even we approve proposals here, including that of the Senate, that remains a proposal. Because the power to ratify or to reject the said proposal belongs not to the President, but to the Filipino people. So there's another distinction.
Yes, there's no debate about that, no? Mr. Sponsor, Mr. Speaker.
So we can propose, but we cannot conclude. That's the distinction. Because it is only the Filipino people who can conclude whether they will accept it through their power of ratification or they will reject it in a plebiscite called for that purpose.
Yes, I have no debate about that particular power of the people to ratify, you know, via referendum or plebiscite, Mr. Sponsor, Mr. Speaker. But what we are discussing here now is the process, you know, the manner by which we amend, we propose amendments to our Constitution. No? We have to be very clear about this, because as we have admitted and agreed earlier on, this is not just an ordinary lawmaking power that we are exercising here. No? What we are doing here is a special power granted by the Constitution to propose amendments, no? Because these amendments are pertaining to the policies that were already laid down by the sovereign Filipino people in the 1987 Constitution, Mr. Sponsor, Mr. Speaker.
So, when RBH2 was called for the first time, the presiding officer said that the House of Representatives has entered into the exercise of a constituent power. That is very clear, Mr. Speaker, Congressman Zarate. And in fact, the rules that we have adopted now is consistent with the power granted to us by the Constitution in determining the rules of its proceeding. If you look at Article 6, Section 16, Paragraph 3 of the 1987 Constitution, Congress has the power to determine the rules of its own proceedings, and its proceeding includes the proceedings to amend the Constitution.
I respectfully disagree with the good sponsor, because that particular section in Article 6 did not say that it includes power, it includes such powers, no, pertaining to the amendment of our Constitution. Because, as I've said, very particular po, no, yung provision in the amendment of our Constitution is in Article 17, no. So, possibly my next question related to that, Mr. Sponsor. You mentioned, and I recall this very clearly, that during our committee hearing, that's the beginning of our exercise of our constituent power, no? And you said that this is now the Constituent Assembly, as envisioned by the Constitution in Article 17. To the appreciation of the good sponsor, Mr. Speaker, isn't there no longer a need for both houses of Congress, the House and the Senate, to come together and before considering proposed amendments to the Constitution, that they will have to convene themselves into an assembly, no? As in relation to Section 1 of Article 17, because it only mentioned Congress. Congress by upon a vote of 3/4 of all its members. So it did not say Congress separately upon a vote of 3/4 of each house may propose amendment to the Constitution. So isn't there a need, good sponsor, Mr. Speaker, for both houses to come together and constitute themselves into a constituent assembly?
Mr. Speaker, allow me to read the provisions of Article 6, Section 16, Paragraph 3 of the 1987 Constitution. It states that each House may determine the rules of its proceeding, punish its members for disorderly behavior, and with the concurrence of 2/3 of all its members, suspend or expel a member. A penalty of suspension when imposed shall not exceed 60 days. So it is explicit that each House may determine the rules of its own procedure. So, pursuant to the said provision of the Constitution, Congress has the power to determine the rules of its proceedings. And under the rules that we have adopted, proposals for amendment to the Constitution shall undergo the procedure for the enactment of the bills. In fact, a uniform rule between houses is not necessary, since the Constitution allows Congress to propose amendments to the Constitution in the same way as it legislates a regular bill or law. In fact, this is even simpler. The procedure makes it more simpler.
Yes, the good sponsor is referring to Section 145 of our rules. Is that correct? That the proposed amendments shall follow the procedure for the enactment of bills. Is that
that's it's Section 15, Paragraph 2 of Internal Rules of Procedure adopted by the Committee on Constitutional Amendments. And under the House rules, I think it's Section 145.
Yes, Section 145, no, in relation to Section 100, 44, no? Which, which says in Section 145, the adoption of resolutions proposing amendments or revision of the Constitution shall follow the procedure for the enactment of bills. So that is why you are saying that we are now doing this, no? Just like in the ordinary legislative process, no? There's a first reading, there's a second reading, period of amendment, debate and amendment, and finally third reading, then send this proposal or resolution of both houses to the Senate. So it's the position now of the good sponsor, Mr. Speaker, that there is no need for both houses to constitute itself, to convene and constitute itself as an assembly that will now accept or entertain proposed amendments to the 1987 Constitution. There is no need for that.
Well, there is no need for a prior act of convening Congress into a joint session because the Constitution does not prescribe for it. So you cannot supplant the provisions of the Constitution. Otherwise, we are amending the Constitution. The Constitution does not say that we have to convene first before we can propose amendment to the Constitution. It simply says by Congress and 3/4 of all its members can propose amendment to the Constitution. It is different from the 1935 Constitution, wherein in the case of Gonzales versus Comelec, the Constitution governing, it was decided that there must be a joint session because the 1935 Constitution explicitly provide that Congress in joint session assembled by a vote of 3/4 of all its members in the Senate and the House, voting separately, may propose amendment to the Constitution. It is different from Article 17, Section 1 of the 1987 Constitution, which only provides that Congress, upon the vote of 3/4 of all its members, it does not provide for convening or in a joint session.
Thank you, Mr. Sponsor, Mr. Speakers. And because of that appreciation, no, stand of the good sponsor, Mr. Speaker, there is also no need for both houses to come up or lay down a common rule as to when, how to amend or propose amendment to our Constitution. Is that the stand or the
a uniform rule between both houses is not necessary, since the Constitution allows Congress to propose amendments to the Constitution in the same way as it legislates a regular bill or a law. So we can adopt our own rules as long as in proposing amendment to the Constitution, we act within the terms of Section 17 or Article 17 of the Constitution.
Thank you, Mr. Sponsor, Mr. Speaker. So the House can adopt its own rules, as well as the Senate can adopt its own rules pertaining to how amendments can be proposed in the 1987 Constitution, even if it is already, as you mentioned, exercising its own constituent powers. Is that what the good sponsor is saying?
We have our own rules, and that was adopted prior to proposing amendment to the Constitution. I don't know with our counterpart in the Senate whether they have already an adopted rules that will govern their chamber in proposing amendment to the Constitution.
So may I inquire, Mr. Sponsor, Mr. Speaker, what if in the event the rules adopted by the House conflicts with the rules adopted by the Senate, which rule will prevent now? Considering that, again, the Constitution did not also mention how and when, it only mentions Congress by a vote of 3/4. If we follow the logic earlier mentioned by the good sponsor, since the Constitution did not require Congress to convene and constitute itself as a constituent assembly, then that remains a question. What rules will now govern? Can the House and the Senate just say that we have our different rules to govern the proposed amendments and that's it, Mr. Sponsor, Mr. Speaker?
As I've learned, Mr. Speaker, the Senate also espoused the same procedure in enacting an ordinary bill or a law. In fact, when they conducted a committee hearing, they've done it in such a way that they followed the procedure in enacting a bill. Also, the resolution of both houses of Congress filed by Senator Bato and Tolentino, and the resolution filed by Senator Lacson and the Drilon formula also espouse that Congress makes proposal in the course of its lawmaking function. Ganun din po yung kanilang procedure na tinatahak ngayon sa Senado.
Yes, I recall that, Mr. Sponsor, Mr. Speaker. In fact, at one time or another, that mode of amending our Constitution was labeled as the fourth way of amending our Constitution. No? Just go through the regular legislative means, no, of passing our Constitution. And this is exactly what we are doing now. No? We adapt. The House and the Senate adopts its own rules, no? And the amendment, according to these rules, shall just follow the process of, or the procedure for an enactment of an ordinary bill. No? There's a first reading referral to the committee, second reading, etc., etc. Now, at any rate, Mr. Sponsor, Mr. Speaker, so since both houses will adopt its own rules, and in fact, both houses adopted separate rule or respective rules on how to amend the Constitution. What we have now in the House is resolution of both houses number 2. There is also a separate resolution in the House, in the Senate. In fact, in the Senate, it's not only limited to amending the economic provisions of our Constitution. If I can recall it right, the Tolentino de la Rosa resolution contains some political amendments, no? Because it mentioned democratic representation. They want to amend the provisions in our Constitution pertaining to democratic representation. So, in such a case, Mr. Sponsor, Mr. Speaker, no? Ito yung tinitingnan eh. Sinasabi ko eh. If only, considering that Article 17 says Congress by a vote of 3/4, if only Congress, I mean the two houses did come together and decide in the first place, decide what particular or proposed amendments will be deliberated by both houses, it can preclude a situation where there's a conflicting set of amendments that will be proposed by one house and another by the Senate, Mr. Sponsor, Mr. Speaker. May we get the comment on this by the good sponsor?
Well, if there is a conflict between the Senate and the House version on the proposed amendment to the Constitution, then it can be reconciled in a conference committee. And upon reconciliation, both houses will return and have it ratified by the respective houses, but it requires at least 3/4 vote of all its members voting separately.
Okay. So the situation we are envisioning is just like a bicameral conference committee, to
reconcile,
harmonize and reconcile possible conflicting provisions, in the resolution passed by the House and passed by the Senate. Is that the situation envisioned by the good sponsor?
That is correct.
And after which, it will be returned back to each House for the ratification of the approved substitute resolution. Is that
Yes,
correct?
but it requires 3/4 vote of all its members voting
So,
separately.
so the voting threshold is still 3/4.
Yes.
Not only in the passing of the resolution, but also in the ratification of the resolution.
On third reading, it requires 3/4 vote of all its members. Then, on the conference committee where they have decided to harmonize the conflicting provisions, upon its submission for ratification to both houses of Congress, it requires another 3/4 vote of all its members.
So, therefore, Mr. Sponsor, Mr. Speaker, even if the House will only adopt a resolution that contains amendments to the economic provisions of the Constitution, if such a resolution will later on be amended, no? Or changed in the bicameral conference, no? And it will now include other amendments, political and otherwise, no? So that will not, the statement now of the good sponsor as well as the leadership of the House that we will limit our amendments to the economic provisions is not actually binding at all, Mr. Sponsor, Mr. Speaker.
Well, the reconciliation will only be confined to the finished product, meaning any provisions that will be inserted which is not German or related to the restrictive economic provisions, I think would be out of order.
Come again, Mr. Sponsor, Mr. Speaker.
What I'm saying is, in the reconciliation, harmonization of those conflicting provisions in the conference committee, in the way I understand it, you cannot just insert provision that is not German or related to the subject matter, which is the restrictive economic provisions of the Constitution, so that if you will insert provisions that are not generally related or not German to the restrictive economic provisions, I think that is out of order.
Thank you, Mr. Sponsor, Mr. Speaker. That is precisely why I pointed out in this, when both houses did not come together yet, no? And decide on common proposed amendments, no? As I've said, ang sa Senado ngayon, it's not only about economic provisions, no? They want to also discuss some political amendments, no, related to democratic representation, no?
In the resolution of both houses of Congress filed by Senator Win Gatchalian, that's RBH1, it says resolution of both houses of Congress proposing amendment to certain restrictive economic provisions of 1987 on Article 12, 14, and 16. Pareho sa atin, sa RBH2.
I'm referring to the, Mr. Sponsor, Mr. Speaker, I'm referring to the Tolentino de la Rosa, I think, resolution, no? Which did not limit to economic provisions in their proposed amendments, Mr. Sponsor, Mr. Speaker. So what I'm saying here, Mr. Sponsor, Mr. Speaker, considering that both House, separately, the House is, while it limits its proposed amendments to economic provisions, certainly the House cannot dictate on the Senate to also limit its proposed amendments to economic provisions. Is that correct, Mr. Sponsor, Mr. Speaker? No, owing to the bicameral nature of our Congress. Is that a correct statement, Mr. Sponsor, Mr. Speaker?
Sa aking hong pagkakaintindi ay upos na upos ang Senado pagdating sa panukala sa pag-amenda sa mga political provisions. Ang akilahong positibong naririsibing mensahe ay pagdating sa restrictive economic provision ng ating saligang batas, ay meron silang pag-asa o pwedeng pag-usapan pagdating lang sa economic provisions ng ating konstitusyon.
Yes, but that will not erase the fact or that indeed some political amendments can be discussed and even proposed in the Senate. Is that correct, Mr. Sponsor?
I fully understand your anticipation. Pero hindi naman po natin pwede diktahan yung proceedings doon sa Senado. At tayo lamang po dito, kung pag-uusapan natin yung ating proceedings dito sa panukalang pag-amenda sa ating konstitusyon, ay nakatutok lamang po tayo sa restrictive economic provisions of the Constitution. So premature pa ho na or i-preempt natin yung kanilang aksyon doon sa Senado.
We're not, yes, good sponsor, Mr. Speaker, we're not preempting, but we're just exploring the possibilities, no? Considering, as I've said, no, that we are separately discussing proposed amendments, no, to the Constitution. Now, in the event, for example, Mr. Sponsor, Mr. Speaker, that indeed, in the event, no, in the realm of possibilities, that the Senate version of its resolution contains some amendments, not limited to economic amendments, and this proceeding goes logically to a bicameral conference meeting. Will the good sponsor, Mr. Speaker, state for the record whether or not the good sponsor will support a proposed amendment to the Constitution later on that contains political amendments, Mr. Sponsor, Mr. Speaker?
I've stated already, Mr. Speaker, that any proposal or insertions of any provisions not related to restrictive economic provisions of the Constitution, to me, is out of order, even in this plenary and more so in the conference committee. Ang layunin po ng ating pag-aamenda sa konstitusyon, alinsunod po sa RBH 2 na may akda po ay ang ating speaker ay tumutok lamang po sa restrictive economic provisions of the Constitution.
Salamat, kagalang-galang na sponsor and Mr. Speaker. Siguro po sa iba pang mag-interpellate in the coming days ay tatalakayin din uli yung procedural matters, no? Kaya mararapatin ko na pong pumunta sa iba pang mga usapin, no? Especially doon sa substantial na usapin sa pagbabago ng ating saligang batas, no? Na binanggit nyo nga po kanina, you already mentioned, this is not actually the first time, this is the third time that such amendments are being proposed, no? On the protectionist provisions of our Constitution, no? As it is now, it appears that we are on a rush, no? As compared to the previous attempts, no? To open up our economy to foreign investments, no? In fact, we are using this COVID-19 pandemic now as the reason in proposing amendments to our Constitution. Is that a correct appreciation of why we are doing this, Mr. Sponsor, Mr. Speaker? Because I heard during sponsorship speeches that the current crisis aggravated by this pandemic is one reason why we have to push for the amendment, no, of this protectionist provision. Mr. Sponsor, Mr. Speaker.
Maliho yung impresyon na minamadali po natin. In fact, ito ho ay pagpapatuloy ng usapin sa proposed amendments to the Constitution. In fact, in the committee level, based on the record, nagkaroon ho tayo ng 8 committee hearings. 5 was done by former chair, now Deputy Speaker Rufus Rodriguez. And during my chairmanship, 3 ho yung ating hearing sa committee sa committee level. Naimbitan ho lahat ng mga eksperto sa ekonomiya, nagtuturo sa iba't ibang universidad, sektor ng ating ekonomiya, lalong-lalo na ho yung mga negosyante, mga namumuhunang dayuhan, those who are members of the Joint Foreign Chamber of Commerce. So, in fact, if you will talk about the timing, I think, as I always say, it is always the right time to do the right thing, and the right thing is really to lift the restrictive economic provisions of the Constitution. In fact, it is long overdue. Marami na hong sinayang natin na oras dito since the 13th Congress when it was first proposed to amend the Constitution. So, matagal na ho yung debating ito.
Salamat, kagalang-galang na sponsor. Ang binabanggit ko po na nirarush natin ay yung nabanggit ninyong kailangan buksan na ang ating ekonomiya. I'm not saying that we are rushing the processes here in the House, no, but ang binabanggit ko pong we are rushing is to open up the economy because of this crisis now, no, this pandemic that we are experiencing, no, at nahihirapan lang ating mga kababayan. But as I observe, Mr. Sponsor, Mr. Speaker, no, ito yung pagkakaiba ngayon, no, nung mga nakaraang panahon, ang emphasis is on attracting more FDIs. But now, nadagdagan ng kadahilanan itong ang pandemya ng COVID, no. Now, with the kind indulgence of the good sponsor, I still have a lot of questions pertaining to this second part of my interpellation. But may I request Mr. Sponsor, Mr. Speaker, for a continuance, as I was alerted by the floor leader that some matters for third reading will still be up for consideration, if the good sponsor will allow, and the good speaker will also allow.
Thank you, Congressman Zarate. And likewise, thank you to the Honorable Chairman, Majority Leader.
We pose no objection to giving the gentleman from Bayan Muna Party List a continuance of his interpellation, Mr. Speaker. Mr. Speaker, before we proceed with the consideration of resolution of both houses number 2, may I request that we recognize the guests of the Honorable Speaker Lord Alan Velasco and Deputy Speaker Michael Romero, who are in the gallery right now. They are the following: Bishop Roberto Gaa, Bishop of Novaliches; Bishop Jose Colin Bagaforo, National Director, CBCP Caritas Philippines, Bishop of Kidapawan; third, Father Antonio Labiao Jr., Executive Secretary of the CBCP Caritas Philippines; Father Tito Kaluag, Coordinator, Building Networks Compassion Project, CBCP Caritas Philippines; and Ms. Jing Henderson of Caritas Philippines.
May we ask our guests to rise? Welcome to the House of Representatives.
Thank you, Mr. Speaker. Mr. Speaker, resuming the consideration of resolution of both houses, I respectfully request that we recognize the Senior Deputy Majority Leader, Jesus Crispin Remulla, for his interpellation.
Congressman Remulla, are you ready? Honorable Remulla, are you ready? Yes, you may proceed.
Salamat po, Mr. Speaker, sa pagkakataong ito. Isang magandang hapon sa ating sponsor ng RBH2, Resolution of both houses number 2. Yun po ang ating tawag sa pag-uusapan natin ngayong hapon. Tama ho ba, Mr. Sponsor?
Tama po. Resolution of both houses of Congress number 2, which seeks to propose amendment to the Constitution, specifically Article 12, 14, and 16 of the 1987 Constitution.
Kapag sinabi ho natin na resolution of both houses, Ang ating pong sinasabi rito ay ang ating Kamara, ang House of Representatives at ang Senado ay magkatugma at magkasundo sa pagbibigay ng ganitong usapin para sa taong bayan. Bale, sinasabi ho natin, it is a resolution of both houses. Tama ho ba yun?
Well, yun po yung form na isinasaad sa ating rules na when we propose amendment to the Constitution by Congress exercising its constituent power in a separate session, ang dapat hong i-file natin na resolution ay resolution of both houses of Congress which contains the proposed amendment. This is Congress exercising its constituent power in a separate session.
Kaya kagaya na sinabi kanina sa mas nauna ho sa akin, ang usaping ito ay ginagawa natin sa ilalim ng ating rules via the legislative mode o sa paggawa ng batas, yun ang ating sinusunod ngayon na pamamaraan upang gawin itong charter change proposal. Tama ho ba?
Tama po. Sa pamamaraan ng ating kapulungan, ang sinasabi ho ay proposals for amendment to the Constitution shall undergo the procedure for the enactment of bills. And sabi nga ho doon sa Section 15, Paragraph 2 ng Internal Rules ng Committee on Constitutional Amendments, ito nga ho yung pamamaraan na isinasaad. At ito na ho yung sinusundan ng resolution of both houses of Congress na ang walang ibang may akda kundi ang ating Speaker.
Ngunit, hindi lang ho ito ang natatanging paraan upang palitan ang ating saligang batas. Meron pa hong ibang pamamaraan. Tama ho ba?
Tama po. Yung pangalawang pong pamamaraan ay Constitutional Convention. Yung pangatlo po ay People's Initiative.
Ngayon, yung People's Initiative mukhang mahirap gawin sapagkat nung pinag-aralan ng COMELEC ang gawain ito, sabi nila ilang bilyon na magiging gastos kung sino man ang may nais gumawa ng People's Initiative mode. Tama ho ba? Mas mahal pong aabutin kung People's Organization ang magpropose para ho dito, it's too expensive a proposition for whoever wants the People's Initiative to flourish. Tama ho yun.
Well, ang sinasaad po ng konstitusyon ay pagdating sa People's Initiative, piecemeal amendments lamang. Kumbaga, hindi po pwedeng mag-propose to revise the Constitution. At tama po kayo, pagdating sa gastusin, talagang magastos yung People's Initiative dahil it requires the verifications of the signatures of the 3% votes or 3% who signify to amend the Constitution in each
Of every district.
of every legislative district
Every legislative district
in the entire country.
sa buong Pilipinas.
So that kung may isa lamang na legislative district fails to deliver 3% of the signature of the registered voter ay magpapalya para sa akin yung People's Initiative. Kasi ang sinasabi at ang pinapanukala ng ating konstitusyon ay dapat each legislative district.
Ngayon, sa kasaysayan ng Pilipinas, marami na ho tayo naging saligang batas. Bibilangin natin ang Malolos Constitution, ang 1935 Constitution, ang 1973 Constitution, at 1987 Constitution. Tama ho yun, no? Iyon po yung mga saligang batas sa pinagdaanan ng ating bansa sa ating kasaysayan bilang isang bansa.
Tama ho kayo, ang naabutan ko lang po ay 1987 Constitution. Yung iba pong mga konstitusyon, hindi pa ako pinanganak.
Yung tatlong saligang batas na nagkaroon tayo, sa Malolos, meron silang parang CONCOM, di ba? Nagkaroon ba sila ng Constitutional Convention? Paano sinulat ang Malolos Constitution?
Parang ganun yun, narinig ko rin ho yun. At, pero hindi ako makakapagsabi na yan ay based on facts. Pero no, in fact, in the 1935s, 1973, they provide also for a modes wherein Congress can propose amendments to the Constitution as well as call for constitutional convention.
Mas kilala natin ang 1935 Constitution at 1973 Constitution at 87. At sa tatlong yan, sa 1935 Constitution, nagkaroon tayo ng Constitutional Convention. Lahat ng delegado ay elected para lang gumawa ng saligang batas. Sa 1973, ganoon din, nagkaroon tayo ng 1970 Constitutional Convention, pero nagkaroon ng martial law at natapos ito 1973 nung may lawmaking power ng presidente. At noong 1987, revolutionary government, isang constitutional commission ang nag-usap-usap upang gumawa ng isang saligang batas. Mga delegado na nominado ng Pangulo ng Republika ng Pilipinas na si Corazon Aquino. Tama ho yun, no?
Tama po yun.
Ngayon, ang ginagawa natin ngayon ay kakaiba sapagkat ito yata ang unang pagkakataon. Bukod, ang parity amendment ba ho ay ginawang amendment sa Constitution na ginawa ng Kongreso o ito po ay ginawa rin ng CONCON?
Yung alin po? Yung...
Ilang pagkakataon na ba nagkaroon ng pagbabago ang saligang batas na ang gumawa po ay Kongreso?
Yung 1987 Constitution po ay gawa ng Constitutional Commission, 1986 Constitutional Commission. Opo. So yun lang ho yung aking sigurado. Hindi ko po napag-aralan yung paggawa ng 1973 at 1935. Lalong-lalo na po yung, kasi yung evolution ng ating Philippine Constitution starts with the 1899 Malolos Constitution. And then nagkaroon ng Philippine Organic Act of 1902. And then sumunod po yun ng 1935 Constitution. And then nandun yung Jones Law of 1916.
1916.
And then 1973 Constitution. And then we have the 1986 Freedom Constitution. And we have at present the 1987 Constitution, which was adopted by the Filipino people on February 2 of 1987. So 34 years old na po ang ating konstitusyon.
Ngayon, kung sa pag-uusapan ang pagbabago na gagawin natin sa saligang batas, kailangan ang gawin natin, ginagawa natin ngayon ang debate rito sa plenary hall. Ngunit, sa forma ng inyong pinaliwanag sa committee hearings, tila nawawala ang Senado sa usapin. Ano ba ho ang papel ng Senado sa charter change?
Well, yung papel nila ho ay binigyan din sila ng kapangyarihan ng ating konstitusyon to propose amendments or revision to the Constitution. Ayun ho yung nakasaad sa Article 17, Section 1 of the 1987 Constitution, that when you speak of Congress, it speaks of the Senate and in the House of Representatives. And the Constitution specifically made Congress as a constituent assembly by virtue of that power granted to, in the said article, Article 17 of the Constitution.
So ang tingin nyo, ang inyong sinasabi rito, hindi tayo pwedeng gumalaw kung wala ang Senado. Ang sinasabi nyo, voting separately, pag hindi bumoto ang Senado, wala na mangyayari sa charter change. Yun ang sinasabi nyo.
Ganun ho yung wordings o yung salita ng ating konstitusyon.
Ano ho nakasulat sa Constitution? Pakibasa po.
Ang
Yung
sinabi
specific
ho ng
provision
ating konstitusyon,
ng 1987 Constitution.
Article 17 speaks of amendments or revision. Section 1, and may I read, any amendment to or revision of this Constitution may be proposed by, number 1, Congress upon a vote of 3/4 of all its members.
Yun. Tapusin natin doon, ha? Doon muna tayo. Congress by a vote of 3/4 of all its members. Sino ba ho ang Congress?
Congress, when you speak of Congress, it speaks of the House and the Senate.
Kaya malinaw. Malinaw po na 3/4 of Congress, kumbaga ho, sa Latin, verba legis rule ang ating pinag-uusapan. Malinaw na malinaw ang sinasabi 3/4 of Congress ang boboto para mag-propose ng amendment sa Constitution. Tama ho yun.
Klarado ho kasi na ang ating saligang batas, ang sinasabi o ay ang Kongreso. And we
Yun.
speak of
Hindi malinaw po yun, no? Ang Kongreso, hindi niya sinabi na 3/4 of both houses voting separately. Wala hong sinabing ganon ang ating saligang batas.
marami hong interpretasyon.
Hindi ho interpretasyon ang tinatanong ko. Kasi ang batas natin, alam naman natin, as lawyers, when the law is clear, there is no room for interpretation. Tama ho yun o mali?
Well, para sa akin ho, sinasabi nga ho natin that ang Kongreso, pag sinabi nating Kongreso, base sa nakasaad sa Article 17, Section 1 ng ating saligang batas, it speaks of the House and in the Senate. So, and it says also that by a vote of 3/4 of all its members, meaning yung membro ng Senado at ng Kongreso.
Iyon po ang inyong interpretasyon, ngunit hindi po yun ang sinasabi ng saligang batas. Ang sinasabi ng saligang batas, Congress by a vote of 3/4 of all its members may propose amendments to the Constitution. Tama ho. Yung exact wording ng Constitution, yung binasa nyo kanina. Di
The
ba ho ganon?
Congress, the
By a vote of
Congress,
3/4.
comma, upon a vote of 3/4 of all its
Yun.
members.
Maliwanag, no? Congress by a vote of 3/4 of all its members. Hindi kagaya ng 1973 Constitution, ano sabi ng 1935 Constitution, naalala niyo ba yung sinabi ng 1935 Constitution?
Well, when you speak of members under Article 6, these are not individual senator or individual representative. It is the Senate and the House.
Hindi, kasi
So that it
ito,
means 3/4 of the Senate and para sa akin, 3/4 of the House. And yun din ho yung sinasaad ng ating resolution of both houses of Congress. But I fully respect your opinion and your
hindi,
interpretation.
it's not an opinion, it's a statement of the words of the Constitution. Hindi pa ho ako nag-interpret. Ako ho, ang sinasabi ko lang, these are the words of the Constitution. Why are we interpreting it when it's very clear na yun po ang sinabi? Hindi po ako nag-interpret, wala pa akong interpretation. Ang sinasabi ko lang ho, yung exact wording ng ating saligang batas. Di ba ho? Congress by a vote of 3/4 of all its members. Ano ang sinabi sa 1935 Constitution? Sa pagdating po sa amendment ng Constitution.
Klarado ho, ang sinasabi ang Kongreso. When you speak of Congress, we have to interpret it in such a way that we have a bicameral Congress.
Hindi natin pinag-uusapan yun.
House and the
Ang
Senate.
pinag-uusapan lang po natin dito, exact words of the Constitution. I'm not asking for any interpretation. I'm just asking you if you agree with my premise that this is how the Constitution was written.
Uulitin ko po, pag binasa po natin at malinaw na ang sinasabi sa Article 17, Section 1, the Congress, upon the vote of 3/4 of all its members. So when you speak of Congress, it is the House and the Senate. And we speak of also of members under Article 6. These are not individual senator or individual representative. It is the Senate and the House. So that means, para sa akin, and alinsunod na rin sa RBH 2, it means 3/4 of the Senate and 3/4 of the House of Representatives.
Kasi ho, yung ating sinasabing ganyan, malinaw na malinaw, sa 1935 Constitution, ang sinabi niya, Congress, by a vote of two houses, by a vote of 3/4 of all its members, with both houses voting separately. Malinaw po yan sa 1935 Constitution, di ba ho?
Ang pagkakaiba po kasi sa ating konstitusyon ngayon, 1987 Constitution, doon sa 1935 Constitution is that in 1935 Constitution, it is explicit that Congress in a joint session assembled by a vote of 3/4 of all its members of the Senate and of the House of Representatives voting separately may propose amendment to the Constitution.
Yun,
Sabihin,
malinaw, no? So sinabi niya
Malinaw.
na.
Ngayon,
Yung 1935 Constitution, nilinaw niya na both houses voting separately by a vote of 3/4 of all its members. Tama ho, no? 1935 Constitution.
klarado ho yung provision.
Malinaw. Mas malinaw ang 1935 Constitution.
Malinaw yung 1935 Constitution
Malinaw
na
ho, no?
dapat voting separately.
Yun.
Pero ngayon po, ang sinabi lang, ang sinaad lang sa ating saligang batas ay Congress
By a vote of 3/4 of all its members.
by vote of 3/4 of all its members. Pero hindi gusto hong sabihin na voting jointly yon. Dahil if you will compare it to 1935 Constitution, klarado ho yung 1935 Constitution. Dapat voting joint, in a joint session din. Gusto
Joint session din.
hindi rin kailangan sa ating konstitusyon ngayon na magkaroon tayo ng joint session.
Kaya, ang tingin nyo ba, yung mga miyembro ng 1987 Constitutional Commission, 1986 Constitutional Commission, ay pinag-aralan din ng ating naging saligang batas noong 1935 at 1973 bago nila sulatin ang mga katagang yan? Ito ba ho'y pinag-aralan? Ang tinatanong ko sa inyo, yung mga members ng 1935 Constitutional Convention at 1986 Constitutional Commission ay pinag-aralan nila yung kanilang mga sinulat at pinag-aralan nila yung ibang saligang batas bago sila gumawa ng bagong saligang batas.
Sa tingin ko naman po, pinag-aralan nila ng maigi.
Oho. Kaya, kung talagang yun ang intensyon, sa tingin ko ho, nilinaw na nila. Kasi nakasulat na dati yan sa 1935 Constitution, bicameral legislature, katulad na meron tayo ngayon, pero nilinaw talaga. Naging malinaw na 3/4 of all its members voting separately. Di ba ho? No? Yun yung 1935 Constitution.
Para sa akin, malinaw yung Congress by a vote
3/4 of all its members.
When you speak of Congress,
naniniwala
it is
kayo?
the Senate and the House.
Naniniwala ho kayo na ang Senate po natin ay may veto power sa House. Mas mataas po ang Senado kaysa sa ating kapulungan. Yun po inyong paniniwala.
Sa tingin ko naman po ay hindi naman ganon yung intensyon. Except that ang pag-aaproba ng anumang panukala sa ating saligang batas ay hindi nakasalalay sa ating mga mambabatas. In fact, it is the people who has the power to ratify.
Yun. Yun ang gusto ko marinig. Kasi ang trabaho ng Kongreso ay mag-propose ng amendments at ang boboto nito, ang magdidesisyon, ay taong bayan.
Well, tama po kayo. That is based on their power of ratification and based on the principle that sovereignty resides in the people and all government authorities
Yun.
emanate from them.
All government authority emanates from the people, sovereignty resides in the people. Yun po ang prinsipyo natin sa ating saligang batas.
I fully agree with you, Senior Deputy Majority Leader.
Kasi ang nangyayari ho ngayon, parang hindi yata pinag-uusapan itong pagbabago ng saligang batas sa Senado. Ito ba'y nakarating na sa may committee report na ba ho ang Senado tungkol dito sa saligang batas natin?
Wala pa ho. Nasa committee level pa lang ang kanila.
Nakailang hearing na ba ang committee ng constitutional change ng Senado? Nakailang hearing na ho ang ating Senado tungkol sa usaping ito ng charter change.
Sa aking hong pagkakaalam ay isa pa lamang po.
Isang hearing. At kung hindi nila gawin to, ay parang nag-asaya tayo ng laway at papel at oras sa ating trabaho rito sa mas malaking kapulungan ng Kongreso ng Republika ng Pilipinas. Baliwala na ang ating ginagawa kung ayaw ng Senado.
Sa tingin ko ho, mayroong silang obligasyon na nakapalaman sa ating konstitusyon to push for those meaningful constitutional reform, especially kung ang isang probisyon sa ating konstitusyon ay outdated na o kumbaga it is no longer responsive to the needs of time.
Kaya ang nangyayari ho ngayon, yung 24 na tao lang ang magdidesisyon kung ang taong bayan ay boboto o hindi tungkol sa charter change. Kung ayaw ng Senado o wala sa mood o wala sa tamang timpla ang Senado, pwede hindi na nila pag-usapan to at kalimutan na natin ang taong bayan. Yun po ang inyong sinasabi. Okay lang yon. Nakalimutan tayo ng Senado, kalimutan na ang taong bayan kung ayaw ng Senado. Tama ho yun.
Well, wala pa hong okasyon or pangyayari na isang sitwasyon na kumbaga inaksyon na natin yung isang panukala sa pag-amenda sa konstitusyon at ito ay hindi binigyan ng pansin ng Senado. Siguro ho, magiging test case ito kung maaprubahan natin ito sa third reading at i-transmit natin sa Senado at hindi ito bigyan ng pansin, baka yung ang iyong pong hinala at agam-agam ay baka nga po.
Kasi ang kasaysayan ng ating bansa, ilang presidente na ang nagsabi na kailangan palitan, baguhin ang ilang kataga ng saligang batas, ngunit kahit kailan, panahon ni Pangulong Ramos gusto niyang palitan ang saligang batas, hindi pumayag ang Senado. Wala nang nangyari. Panahon ni Pangulong Pangulong Estrada, naging usapin din ang saligang batas, ngunit hindi rin ginalaw ng Senado. Panahon ni Pangulong Arroyo, naging usapin din ang charter change, hindi rin ginalaw ng Senado. At panahon ni Pangulong Noynoy, ewan ko lang kung nagkaroon ng effort sa charter change, pero wala rin nangyari. Ang sinasabi ko rito, sa ating karanasan, may veto power yata talaga ang Senado sa atin. Pag ayaw ng Senado, wala na magagawa ang taong bayan sa mga pagsususog na ginagawa natin dito sa mas malaking kapulungan ng Kongreso. Wala na tayong bilang. Ang Senado lang ang masusunod. Yun ho ang gusto nyo mangyari.
Well, tama ho yung inyong obserbasyon. Sa katagal-tagal na hong nakabinbin ito sa Kongreso ay talagang hindi ito
pero
umusad.
sa kaduluduluhan, sino ho ang magdidesisyon tungkol sa ating saligang batas? Sa kaduluduluhan, ano po ang magiging palakad at paano ho madidesisyonan na magkaroon ng pagbabago ang saligang batas? Sino po ang magdidesisyon?
Sinabi ko na ho kanina that it is the people, ang taong bayan who is the source of all government powers, including powers in the Constitution.
Yun ang gusto kong marinig kasi ang nangyayari po sa atin, kahit ano ang gawin natin na tayo ay mga representative, no? Tayo ay mga kinatawan ng taong bayan sa bawat sulok ng Pilipinas. Kinatawan tayo ng taong bayan. Kompleto ho tayo. Lahat ng distrito, 255 legislative districts. Tama ho ba yun? Ilan ho legislative district natin? Halos ganun na ho, no? At 304 na tayo rito ngayon. Sa lawak ng ating membership dito sa Kamara, represented na natin ang buong Pilipinas. Tama ho?
Tama po.
Ngayon, pag sinabi ng Senado na ayaw namin, kami ang prima donna, kami lang ang pwedeng masunod. Baliwala yung taong bayan, kami lang ang masusunod. Papayag ba kayo doon?
Sa akin ho, katanungan.
Kayo ba'y pumapayag na sabihin ng Senado na kami lang ang masusunod, hindi ang taong bayan?
As I've said earlier, the power to ratify any proposed amendment to the Constitution belongs to the Filipino people.
Yun ang gusto kong marinig. Kasi sa kaduluduluhan, ang pinag-uusapan dito, yung boto ng bawat tao sa lansangan, bawat tao na naroon sa karagatan upang maghanap buhay, naroon sa bundok, naroon sa factory, naroon sa barangay hall, lahat ng tao, lahat ng nagtuturo, lahat ng mamamayan. Hindi ba sila dapat ang nasusunod sa ating pong sistema ng gobyerno at hindi po 24 na tao lang na nagsasabing ayaw namin yan?
Well, tama po kayo.
Kung gayon, marahil, huwag tayo magsasalita ng patapos. Kasi kagaya niyan, tatanungin kayo kung anong ating patakaran na sinusunod para mag-charter change. Ang sinasabi natin, ang rules of the House of Representatives. Tama ho? Diba?
Meron ho tayong pamamaraan sa pag-amenda sa ating
Pero,
Constitution.
hindi lang ho yan ang paraan na nakasulat sa ating rules of the House, di ba? Marami hong nakasulat na ibang mga bagay sa ibang batas na dapat natin tingnan para tayo ay magbago ng saligang batas. Hindi lang po yung House rules natin. Tama ho?
Tama po.
Kagaya niyan, kung gusto ho natin mag-constitutional convention, majority lang ba kailangan?
2/3.
2/3, no? Dati, sa 1973, sa 1935, majority lang, di ba, ang kailangan?
Opo, pero
Of both
all
houses.
for a CONCOM, 2/3 vote of all members of the CONCOM.
Konkon, sa Konkon. Oh. Pero, yun, ba't hindi natin ginagawa yun? Ano ho ang tingin nyo kung Konkon na lang ang ating gawin? Para talagang wala na hong prima donna. Lahat ay pantay-pantay, bawat distrito ng bawat sulok ng Pilipinas. Bakit hindi ganun?
Well, in the final analysis po, bawat isa sa atin bilang representante ng ating ng taong bayan ay may pananagutan sa taong bayan. Kung hindi man umakto yung Senado, ay let the people judge them on not acting on this meaningful constitutional reform.
Ano ang nakasulat sa saligang batas tungkol dito sa Constitutional Convention? Pakibasa ho yung mga kataga na nakasulat sa Article 17 para ho marinig na ng taong bayan tungkol po sa Constitutional Convention para maging malinaw po ang ating usapan.
Alin po yung mga kataga? Ano yun?
Yung tungkol sa Constitutional Convention po. Ano nakasaad sa ating saligang batas? Di ba? Ang sabi nung pwede ho tayong tumawag ng Constitutional Convention by a vote of 2/3 of all its members. Hindi pa rin ho sinabing voting separately. May sinabi ba hong voting separately? Wala rin, di ba ho? No.
Well, tama po kayo.
Tapos, ang sabi nga, submit the question of calling for a CONCON. Tanong natin sa taong bayan kung gusto ng CONCON, majority vote lang ng ating members, di ba ho? Pwede natin patakbuhin sa plebisito kung gusto ng tao na palitan natin ang saligang batas.
Pakiulit po yung tanong.
Di ba, ang unang-una, yung Constituent Assembly, yung konsepto ng Constituent Assembly na pinag-usapan sa kaso ng Gonzales versus Comelec, na upon a vote of 3/4 of all its members. Yun po yung unang-una, di ba ho, na Constituent Assembly. Walang sinasabing voting jointly or voting separately.
Well, tama ho kayo.
Pagdating sa pangalawa, ang sinabi, pwede ho tayong magpatawag ng Constitutional Convention, o CONCON, by a vote of 2/3 of all its members. Hindi ho sinabing kasama ang Senado o hindi kasama ang Senado, o voting jointly o voting separately, 2/3 of all its members, pati po sa pagtatawag ng CONCON.
Kasi ho, kalakip yung Section 1 at Section 2. It's all by Congress. Congress can directly propose amendment to the Constitution by a vote of 3/4 of all its members.
Yeah.
Or call, it is we who will call for a constitutional convention. Opo, by a
Vote
vote
of
two-thirds. Opo, opo. Oo.
of all its members.
Well, kung yun o yung nakasaad sa
Yun ang nakasaad, di ba?
Konstitusyon, tama
Walang
ho kayo.
sinabing voting jointly or voting separately. 2/3 of all its members, pwede na tayo mag-concon. Tama ho. Correct. Tama ho yun.
I still subscribe to the view that whenever we call or propose amendment to the Constitution, even calling for a constituent or for constitutional convention, it will be voting separately po.
Pero alam niyo ho ang sinasabing verba legis non est residendum. Plain
Yo,
meaning rule.
Tingnan niyo po, yung kung gaano kung pagkaakda ng Section 1, the Congress, upon a vote of 3/4 of all its members or constitutional convention. Nag-uumpisa pa rin po ito doon sa isinasaad na isang institusyon na ang tinutukoy ay Kongreso.
Pero sa ibang saligang batas, pinaghiwalay nila ang boto. Dito, hindi pinaghiwalay ang boto ng mga framers ng 1987 Constitution. Wala ho sinabing voting separately or jointly. Di ba ho?
Tama po.
Ngayon, kung babasahin natin ang buong saligang batas 1987, malinaw na malinaw ang mga kinakailangan gawin ng bawat house. Sabihin natin, para ho ma-break yung tie for President and Vice President elections. Sabihin mo, nag-tie. Ano ang boto? Majority of all the members of both houses voting separately. Tama?
Well, tama po kayo.
Yan. Pagdating ho sa nomination ng Vice President, if there is a vacancy, upon confirmation by a majority of all members of both houses voting separately. Malinaw ho yun. Nasa saligang batas yun. 1987 Constitution, di ba ho?
Tama po kayo.
Ayan. Pagdating po sa estado ng Presidente when he is unable to discharge his powers and duties, 2/3 of both houses voting separately. Nasa 1987 Constitution po yan. Tama ho?
Tama po kayo.
To revoke the suspension of the writ of habeas corpus and the proclamation of martial law, majority of all members of Congress voting jointly in regular or special session. Tama ho yun.
Ano yung provision po?
Yung sa martial law, to revoke the proclamation of the suspension of the writ of habeas corpus or the proclamation of martial law and or majority of all members of Congress voting jointly in regular or special session. Tama ho yun.
Tama po.
Ngayon, nabasa niyo ba ho yung naging usapin tungkol dito sa pag-revoke ng suspension of writ of habeas corpus and the proclamation of martial law? Nabasa niyo ba ho ang debate ng Constitutional Commission tungkol sa bagay na ito?
Yung minutes of the constitutional deliberation, tama po.
Yung minutes ng deliberation ng Constitutional Commission of 1986 for the writing of the 1987 Constitution. Nabasa niyo ho ang mga usapin dito sa revocation of the suspension of the privilege of the writ of habeas corpus or the proclamation and the proclamation of martial law. Nabasa niyo ho na ang debate tungkol dito sa bagay na ito.
I pass upon the minutes of the
Ang
constitutional.
naging malinaw po rito, kumbaga sa gusto natin mag-interpret, basahin natin ang ating minutes ng deliberations ng Constitutional Commission, ayaw nilang magkaroon ng tie. Ang gusto nila, matapos kagad makadesisyon ng Korte Suprema, at pag may boto na yung two houses, walang basta may boto na yung Senate at House, jointly, sinasabi nila para walang tie, para walang deadlock. Di ba ho, yun ang naging intensyon ng ating framers ng 1987 Constitution?
Well, totoo na there are some provisions in the Constitution which says that Congress should vote jointly. But in the case of amending the Constitution, what it says is that by a vote of 3/4 of all its members, always Congress, by a vote of 3/4 of all its members.
Kaya nga,
Hindi po pwede natin baliin dahil lamang ho sa nagkakailang provision doon sa Konstitusyon.
Sa tingin ko ho, sinadya nila yan. Kaya nila sinadya yan kasi magkakabotohan na naman sa unicameral at bicameral na nanalo lang ng isang boto at para lang wag na lumaba ang usapan, pumayag sila na tapusin na lang yan. Ewan ko lang. Pero tingnan po natin yung iba. Ano sabi sa Section 3, Article 3, Section 3, Number 3, Article 11 ng Saligang Batas? Para to affirm or override the committee report on the filing, on impeachment, filing of the articles, ano ang kailangan? 1/3 of all the members of the House. Di ba ho? Ngayon, to constitute itself as a constituent assembly, ayan, sa parehong chart yan, 3/4 of all its members. Yun lang, di ba? Ngayon, to call for a concon, 2/3 of all the members of Congress. To submit to the electorate the question of calling for a convention, majority vote of all its members, of all the members of Congress. Sa constitutional change sa Saligang Batas, talagang sinabi nila, of all its members lang ang Kongreso. Wala ho silang ginawang voting jointly or voting separately. Ang sinabi lang, of all its members. Consistent po yan, tatlong bagay na nakasaad sa Article 17, iisa lang po ang sinabi. Tama ho yun?
Tama po, Congress by a vote of 3/4 of all its members.
Kaya marahil, meron talagang ibig sabihin ang ating mga sumulat ng Saligang Batas na huwag tayong padadala sa prima donna attitude ng ibang tao. Ang sinasabi lang dito, ang sinasabi ko sa inyo, sa kaduluduluhan, hindi naman tayo nagbabago ng Saligang Batas. Ang taong bayan ang boboto para baguhin ang Saligang Batas. Tama ho yun?
I totally agree. Any proposal we approve here remains a proposal. Meaning we can propose anything, but we cannot conclude because it is the Filipino people base sa kanilang power to ratify wherein they can accept or
Kaya ang
reject.
tinatanong ko sa inyo ngayon, kung hindi ho gumalaw ang Senado, anong gagawin natin? Kung hindi ho gumalaw ang Senado, baliwala ito, pwera tayo, hindi na gagalawin. Tapos na, wala na tayong pag-uusapan.
Well, those
Uwi na
are
lang tayo,
areas
iyak na
that
lang tayo.
we can ask the Supreme Court because the proposal to amend the Constitution, including the manner in which it can be done, can be subject to a judicial review.
At ang kaduluduluhan, sino magdidesisyon kung papasa ang mga susog na pagbabago sa Saligang Batas? Sino ho ang magdidesisyon kung papasa ang mga amendment na ito?
Ang taong bayan pa rin po.
Ang taong bayan. Hindi ho 24 na tao. Hindi ho tayo. Hindi ang
Tayo lamang ho ay ginawang kinatawan.
kinatawan
Para-
tayo na nagbigay ng tanong sa taong bayan kung papayag sila dito o hindi. Di ba ho? Ganun yon.
Tama po.
Ngayon, ito'y unang parte pa lang ho ng aking pagtatanong sa inyo kasi alam ko na meron tayong time limit so dito. Kaya sana po ay pagbigyan ako ng ating floor leader sa susunod na pag-usapan muli itong bagay na ito at sa second round po ng ating usapin. Kasi napakahalaga po ng pagkakataong ito sa taong bayan ng Republika ng Pilipinas. Sa kaduluduluhan, ang magdedesisyon sa pagbabago ng saligang batas ay ang taong bayan. Sa kaduluduluhan, ang maaapektuhan ng mga pagbabago na nais iharap natin sa taong bayan ay taong bayan din. Kung meron tayong pagkakamaling gawin, taong bayan din ang magdurusa. Kaya sana ay pagbigyan po ako muli ng ating floor leader na magtanong muli sa inyo sapagkat ito po ay part 1 lang ho ng usapin na nais ko pong pag-usapan sa bluwagang ito sapagkat napakahalaga na matutunan ng taong bayan ang trabaho ng Kongreso para po malaman nila na tayo po ay nandito, tumatayo para sa kapakanan ng ating bayan at marahil para na rin sa kasaysayan ng Republika ng Pilipinas. Maraming salamat po. Magandang hapon po sa inyo.
Salamat din ho, Senior Deputy Majority Leader Boyeng Rimulya, dahil inilatag niyo ho yung tunay na esensya ng democratic and republican state, that it is the people who is the source of all government powers. In fact, under our declarations of principle and state policy, sovereignty resides in the people and all government emanates from them. Salamat po.
Maraming salamat po.
Maraming salamat to the Honorable Remulla. Likewise, maraming salamat din sa ating butihing Chairman, Honorable Garbin. Majority Leader?
Mr. Speaker, I move that we suspend consideration of resolution of both houses number 2.
Any objection? Hearing none, the motion is carried.
Thank you, Mr. Speaker. Mr. Speaker, I move that we consider on third and final reading House Bill number 7174. And may I request the Secretary General to read the title of the House Bill and call the names of the roll of members for nominal voting.
Secretary General?
House Bill 7174, an act prohibiting the use and display of commercial billboards during typhoons. Roll call of members in consideration of House Bill number 7174. Abante, Abaya, Abellanosa, Abu, Abueg Zaldivar, Abunda, Acop, Acosta, Acosta Alba, Jong, Advincula, Agabas, Agaraw, Aglipay, Aguinaldo, Albano, Almario, Alonte, Alvarez, Franz, Alvarez, Senaro, Alvarez, Pantaleon, Amante Matba, Amatong, Angara, Aragones, Arbison, Arenas, Arroyo, Atienza, Aumentado, Babasa, Bagatsing, Balindong, Banyas, Nograles, Barba, Barbers, Baronda, Berzaga, Bascug, Bautista Bendigan, Bautista, Belmonte, Benitez, Berno, Biason, Billones, Biron, Bolilla, Bondok, Bordado, Bravo, Rosas, Bulot, Bustos, Kabatbat, Cabotchan, Cabredo, Cagas, Calderon, Calixto, Caminero, Campos,